The Honorable Chief Justice and Associate Justices of the Supreme Court.
The House will come to order.
The Senate will come to order.
Well, good afternoon, Chairman Ott and members of the committee, and I'd like to thank you personally, Chairman, for scheduling a hearing on this legislation. I authored Assembly Bill 424 at the request of the Jefferson County District Attorney in my district, Susan Happ, who is with me today. It is meant as legislation to protect everyone who works as an employee in a courthouse. Current law reads that an individual who causes bodily harm to another individual is guilty of battery, which is a Class A misdemeanor. There are also more severe penalties for battery committed against certain public officials. For instance, anyone who intentionally causes or threatens to cause bodily harm to a judge can be found guilty of a Class H felony. This is appropriate and a well-intentioned law. However, there are many more people who work in courthouses all across our state. They range from judges, lawyers, clerical staff, and county maintenance workers. And if they are threatened, I believe that they also deserve justice. Not long ago, there was an incident in the Jefferson County Courthouse that involved an enraged person entering the courthouse and yelled to employees that if I had dynamite, I would blow you up. Now, if he really had explosives, he wouldn't have just blown up judges, but all those that work every day in that building. And similarly, his threat scared not just the judges, but all those in the building that day. Jefferson County DA Susan Happ came to me when it became clear that her prosecutory options were limited. For all the people that could have been hurt if the threat were real, there is nothing currently in statutes that would address what happened in her courthouse that day. DA Happ mentioned to me that her difficulty in trying to file for appropriate charges against the perpetrator for the serious nature of his actions. I worked closely with DA Happ in the intent and scope of this bill to try and find appropriate language so that if something like this happens again in a courthouse in our state, the individual making the threats can be held properly accountable. Under this bill, an individual is guilty of a Class I felony if they intentionally cause or threaten to cause bodily harm to a court employee, which includes circuit court clerks and their employees, employees of the Supreme Court, district attorneys and deputy and assistant district attorneys, and state public defenders. Now, this bill also makes an individual guilty of a Class I felony if they threaten to cause damage to a courthouse and if the threatened action could result in bodily harm to a judge or to a court employee. Now, these threats are unfortunately all too real. Last November, there was a brief lockdown just down the street at the Dane County Courthouse. And until law enforcement was able to determine that that person making the gun threats was not in the building, just a little over 2 weeks ago, there was a threat made to blow up a county courthouse in North Carolina. Now, I hope that the penalties laid out in AB 424 will never have to be used. However, it is better to be prepared than not to have such threats adequately addressed in our state statutes. And thank you again for this opportunity. And now for some more comments, I'd like to turn it over to Jefferson County District Attorney Susan Happ.
Thank you, Chairman, and others. I did approach Andy when this incident happened in 2009 in our courthouse. The first initial charge that you've probably, in reviewing this, thought about was, well, bomb scares. Wouldn't that apply in this case? Bomb scares under 947.015 at first blush is what I charged. Seemed appropriate. Conduct of this nature should be felonious. This was a gentleman who didn't just come in and make one comment. And he did say, if I had dynamite, I would blow this place up. If I had my way, I would bomb you all to hell. He also specifically threatened to kill people. He specifically threatened to kill deputies who responded very specifically, how he was going to shoot them, how they'd be the first ones to go. He'd shoot them in the spine and then in the head. So very specific threats. Unfortunately, the bomb scare statute, of course, covers only bombs, explosives, things of that nature. In the jury instruction to that statute, specifically, we have to be able to prove that the person made a true threat. Now, true threat, as defined under certain case law, specifically State versus Perkins, very narrowly defines what constitutes a true threat. And it specifically is more specific and more narrowly defined than the threats to judges, for example. And so this bill, as proposed, more closely has that language that is similar to the threats to judges. It is more consistent in the treatment of the other persons that are in the courthouse. It also broadens it to things beyond bomb scares or bomb threats. So, for example, with this person who made these threats to killing employees in the courthouse would be addressed in AB 424, whereas right now they are not, because the bomb scare statute simply covers the explosives and only in the true threat context. So we would have had to have been able to prove that this mentally ill and intoxicated person actually related true threat that he believed persons in that courthouse would have thought he meant to act on. And he was very careful. If I had dynamite, if I had my way. Very difficult from a prosecutorial standpoint. Then I looked at threats to injure, which is in section 94330. Very cumbersome statute. It is more of an extortion type statute where you are using a threat to induce or to compel someone to do something that they otherwise wouldn't do, or to make them not do something that they otherwise would do. In this case, I thought long and hard about it. The gentleman came in and he was angry about a parking ticket and the courthouse was closed, and he made a comment, you know, that lady better get out here and let me pay my ticket. Unfortunately, the threat that was on the other end of that was, or I'll blow up this place or something of that nature, was not made directly to this woman. So she did not have the knowledge as a victim of threats to injure that made me feel that I would be able to prove the threats to injure. And it's notable that statute is in 943. That's our property crime statute. It's where we see criminal damage to property, theft, burglary. It's just really not the appropriate place for prosecutors to look to, and it's really a cumbersome statute. If you've looked at the language of the jury instruction, it gets very convoluted, and it's really more of an extortion. In fact, the extortion header is what shows up on the jury instruction to that statute. So we were really at a predicament of what to do with this person, where we knew that the threats were very serious. I mean, the employees were shaken. We are in a volatile work environment, not just in the criminal avenue, but think of your family clerks. Think of your people going through a divorce, restraining orders, injunctions, domestic violence situations. So this was a case where I'm often, as a prosecutor, reluctant to support new legislation because very often the things we have on the books adequately address the situation. This was a case where this person I was only able to convict of disorderly conduct with a dangerous weapon. And to me, that woefully understated the seriousness of the conduct. And I think in this case, putting it right where we have our threats to judges, we protect our Department of Workforce Development workers, we protect our Department of Revenue workers, and I think this is a nice bill that really just sort of shores up some inadequacies in the existing statutes with the idea that in the right circumstance, this should be treated and disposed of as a felony, and I just wasn't able to do it with this defendant in this situation. Thank you.
Thank you both for your testimony. Questions from the committee? Representative Kirkman.
You mentioned the deputies came in and apprehended this individual, I'm assuming. Are deputies covered as well? Because I know in Kenosha County they do have, I didn't read it specifically, that's why I was trying to figure out if deputies and or jailers, you know, if they're non-sworn officers that work in a courthouse.
Our deputies generally are employees of our sheriff's office, even the part-timers, and so I believe they would be covered under the definition of court employee under that sub 5, which would be employed by a county or under a contract to work regularly in the courthouse. And just to clarify too, I mean, this was an individual who came in 3 different times. He went out to his car. People in that courthouse don't know what he's getting. They don't know what he's doing. I had people in my office who literally were so panicked by this that they didn't even recall what they had told other persons at the time of the event, specifically to the bomb scare. So it really is one of those things where this is nice because it requires just the threat to cause bodily harm. And I think in the right circumstance, we still have discretion not to insist on a felony conviction, to go with lesser charges or to charge things as we see fit. But this was just a case where it was so obvious that the statutes that I had at my fingertips just weren't adequate.
Kenosha County has metal detectors as you walk in, but Racine County, it's pretty much open. Do you have any metal detectors as you walk into your court?
We do, and this was a situation though where and we've dealt with some of this to great expense to my county, and I really appreciate them for doing this. We now have doors that will automatically lock after 4:30. So that I can come in with an access card and employees can come with an access card. We did not have that at this time. However, I will say people are coming and going constantly at that time. This gentleman comes in right at 4:30. We also have meetings, county board meetings, other meetings of people who are accessing the courthouse. So those doors will not always be locked. So even though we have metal detectors, after 4:30 they're not staffing them, you're not going through them, and you're going to have citizens and employees who are accessing the courthouse, such that in this case the metal detectors just wouldn't have been able to address the concern.
Thank you, Mr. Chair. Thank you all for being here. The question I have is, again, it's just whether the threat is real or not real. Again, I mean, I understand that you're in very emotional circumstances a lot of time, and again, now you tell me that you do screen, so it's clear that this person really didn't have dynamite because you screen, so they're in the courthouse, and they don't have dynamite, so he's mentally ill, he's intoxicated, and let's just say he was in divorce court and just lost his kids in a custody battle, and he's, obviously upset about that and emotional, and says these words, and you want to put that person in prison.
Is the question, do I want to put that person in prison? I guess it depends. If I have a mentally ill person, that's going to be different, because then there may be not guilty by reason of mental disease or defect, and they wouldn't go to prison. They might be committed either inpatient or outpatient, and we would address those mental health needs. Even with the individual in this case, it would have been a close call on prison, because the mental health issues weren't obvious until much later. In fact, after the case was disposed of, they became even more evident. So it's not necessarily even where you want them in prison, but for example, with an I felony, you have an ability to get a longer length of supervision on probation. You have an ability to impose and stay prison in order to get them compliant with certain things, that may be treatment regimens. So the felony doesn't necessarily mean that we would always insist on a felony conviction. It also doesn't necessarily mean that we would recommend or that a court would order prison, but it gives us that option in an aggravated situation where right now a disorderly conduct is a 90-day misdemeanor. The weapon, if you threaten or use a weapon, adds, I believe it's 6 months. So my maximum exposure on this individual was 9 months in jail, and on one count, 1 year of probation. Whereas a felony would have given me an ability to have him supervised longer, and the potential for prison if it warranted it. But it's not a one-size-fits-all. It's really case-specific to the offender and the history.
Okay, and one more, Mr. Chair, if I can. I maybe can just explain. Right now it's a Class H felony for the judges. Is that staying Class H felony, or are they coming down to Class I with everybody else?
It's my understanding that statute would change, or would stay as it is. I kind of joked with Representative Jorgensen that maybe the judges were more protected in the sense of the courthouse employees only being an I, but that distinction doesn't really bother me. I think judges are in a position where they're sending people to prison, so I think that a little bit additional protection in the sense that they have a higher level felony is understandable. Yeah, I think if we can make it a felony, my concerns are addressed, because then I have the ability to charge up the felony, to get the convictions, and to have the prison exposure and the longer length of supervision, and I think it adequately addresses my concerns if we can start at least with an easy, in terms of provability, it's just a much easier, more straightforward statute as written.
Representative Hebel?
Thank you, Mr. Chair, and thank you both Representative Jorgensen and Susan for your testimony. I've been in your courthouse many times, and you have some of the most pleasant people in the state, but I cannot get through that metal detector very easily. Yeah. It's either a belt buckle or something. Yeah. I can get in Dane County all the time, but I cannot get through yours, so I'm not sure
You're
what
not alone.
It's tough.
I haven't addressed before the officer.
How prevalent is this statewide? You have meetings with district attorneys. Is this obviously you went through a very difficult situation there in Jefferson County. Is it prevalent throughout the state, or is this a very unusual circumstance?
I don't know. I know we've seen different things. I think there have even been some shootings in some courthouses, which may relate again back to security. I know that statistically, when you look at the nature of the environment that we're in, certainly you're going to see more incidences just because you have the family component, you've got the domestic component, you've got people accused of crimes, you've got people who may have, defendants who may have gang affiliations. I mean, there certainly is a heightened concern. I would hope, and I wish I had data for you, that things of this magnitude are not frequent. We get very often after the family court example, the two parties are very upset. We have a nice system in place now where if we think there might be concerns, we'll just make sure on our end that we flag it for a bailiff so that we can have extra security. We can maybe walk parties out, especially on injunctions or restraining orders. Hold a petitioner back while a respondent maybe goes out first. So we have things in place. But I would say in my tenure since 2008, I've probably prosecuted maybe 2 or 3 of these incidents where we have actual threats or damage to property that's going on out in the parking lot, things where it just doesn't go away, where it actually escalates once they leave the courthouse. And if I can, Representative, when you mentioned about the divorce context, when they've been screened, that's a helpful process. But like in this situation, the screening's over because he's coming in after hours. So then we're not able to screen. So thankfully, no dynamite, but we wouldn't have known because he came in and out 3 different times before law enforcement could get to him.
And then what happened to this individual? You whet the appetite.
We did. We ultimately convicted him of disorderly conduct with a dangerous weapon for 3 instances. When I mentioned that going in and out to get a little creative, my recollection is that the court imposed and stayed some prison because when you get up, he was a repeater. So when you get up to repeaters, you can actually have some prison exposure because of his background and his history, with some conditional jail that was also ordered as a part of his probation. He subsequently committed suicide. So it's one of these tragic situations where the mental health issues are so strong, but those are the people I think that we can deal with on the tail end in terms of disposition, so that you're not incarcerating or imprisoning people who are mentally ill, who need mental health treatment, but you're also adequately supervising them for an appropriate length of time on a felony supervision, which of course is going to carry firearm prohibitions and other safeguards. So all in all, it turned out safe. It was an unfortunate end for the defendant, but I think it's a good bill, and I would encourage the committee to consider it.
Thank you.
Representative Kirkman?
Your discussion with Representative Hebel brought up another thought. Does this cover courthouse staff outside of the courthouse? Because I happen to be married to one of those judges who's covered under H, and we've had people at our house. So.
Let me just say this, and first of all, I want to thank you for once again bringing this bill forward and having this hearing today. And if there is something that we've missed or there's a better idea and we can make this bill better, I just want to let you know I'd love to work together with you to do that. And if there's something that as you review this bill, let me know, and let's make it better if we can.
The judges are covered outside the courthouse.
Right.
And I know that there are some circumstances where somebody might see the clerk of that particular judge outside. Mm-hmm. And I'm just trying to think of, threats to that person outside of actually in the course of doing their job.
Sure. And I leave my office often unassisted and late at night by myself in the parking lot. And as a lawyer, I suppose I would read sub 3 sub B to say the court employee is acting in an official capacity at the time of the act, or the threat is in response to any action taken in the official capacity. So if someone comes at me in the courthouse and says, you just sent my husband to prison, and starts making threats, I would hope that would cover it. Maybe it can be better clarified. I wish I had the subsection that relates to the to the judges, but my recollection was we tried to draft it with near identical language with the exception of the definition of the court employee. So I would, to answer your question in a very long, convoluted way, I think so.
Okay. It just adds court employee to the judge.
Right. Well, in subsection 3B, it uses the identical language that's used for the judges, and it doesn't specify a location, but it just requires that the court employee be acting in official capacity, or that the act or threat is in response to any action taken in official capacity. So it could potentially extend beyond the courthouse.
I'll give you a great example. I live in Jefferson, and my daughter likes to go online and Google, and she typed in pictures of Susan Happ, and it was a wonderful front from the road shot of my house, including the basketball hoop in my car and whatever. So I mean, it's a definite thought, especially prosecuting certain types of offenses that I would certainly hope, and I think it does cover that now after looking at B more closely, that that if someone comes to my home or is calling me or is making threats, that this would also have that added protection. Fortunately, I've not had to deal with that, but I'm certain it does happen. I know in Waukesha County there have been solicitations and threats made from the jail, and people have tried to hire people to take out ADAs, for example. So I mean, it happens. Fortunately, not with much frequency, but.
Representative Gray?
Yeah, Representative, I see we address Supreme Court employees in here, and then we address the physical structure of the courthouse. How would the Capitol be treated in a situation like this where we house the Supreme Court?
Well, this isn't a courthouse, so I'd go to Ledge Counsel to...
Well, the term court employee, one of the... one set of individuals covered under that definition is an individual employed by the Supreme Court. It doesn't seem to address other individuals in the Capitol, so I think it's solely limited to sort of the court type scenario. And then in terms of the damage to property, it just refers to a courthouse. So I suppose if there was a threat to cause damage to the Supreme Court, that Section 5 would cover that. I don't know how it would be applied in the case of a threat to the Capitol.
And if I could, that might be something that would warrant independent drafting, simply because, again, not trying to compare, DAs and courthouse employees are I's and then judges are H's, but I mean, truly, if we're looking at our Supreme Court justices, if someone was to be afforded more protection, I think they might be the appropriate persons to warrant at least an H or a G. Well, if we're going to do it, I mean, it does make sense because, I mean, certainly both in terms of all the people, when you look at the number of people who are coming in and out of a Capitol, and just the stature of the person who you're protecting, I think it's an appropriate distinction.
Yeah, I would agree with that. Representative, would you support separate legislation giving protection to Capitol employees?
Absolutely, I'd consider it. I'd love to work with it.
Like parity with this one?
That would be, that's how it works. Get one idea going and look at another. I'd love to work with you on that.
Any further questions? Thank you both for your testimony today.
Thank you.